We'll go ahead and get to work. We'll start by having a hearing on House Bill 2658, and we'll ask Natalie to give us an overview, please.
Thank you, Mr. Chairman. Committee, my nieces are here in the audience today paging, so if you can make me look like I kind of know what I'm doing, I would very much appreciate that.
That doesn't take much effort, because she really knows what she's doing.
Yeah. House Bill 2658 would replace the current list of standard conditions of probation, and it would also allow for special conditions of probation. So the bill amends KSA 216607. That's the statute that provides for the conditions of probation, suspended sentence, or assignment to a community correctional services program. This section is amended to remove that current list, and it would replace it with the following list. So those folks would be required to obey all laws and ordinances, not engage in physical violence, not use, possess, purchase a dangerous weapon if they've been convicted of a felony or is otherwise prohibited by law from possessing that weapon, report to the defendant's supervision officer, remain within the state and other specified areas as defined by the supervision officer, reside at the defendant's approved residence unless there is notification given to the supervision officer that the person's going to relocate, not possess, use, or distribute any illegal drugs or controlled substances, not possess or consume any form of alcohol, or enter an establishment where alcohol is sold or consumed as the primary business, submit to any form of alcohol or substance use testing, participate in assessments, treatment, programming, and other directives, pay restitution, court cost supervision fees, and submit to searches of the defendant's person. This bill would also keep there's a few list in there that are current law that would be kept, which would be paying restitution and the correctional supervision fee, and also to reimburse the state general fund for any expenditures by the State Board of Indigent Defense Services if they were defended by a public defender. The bill would also allow the court to impose special conditions of supervision in addition to those general supervisions provided for above. And I would note that this bill came to you from the Criminal Justice Reform Commission. And I can take any questions.
Questions, committee? All right, not seeing any. Thank you, Natalie. At this time, we have Shelley Williams that was scheduled to give our proponent testimony, but she was called in for jury duty at the last moment. So as I understand, Randy will be giving her testimony in lieu. So Randy, are you with us on WebEx?
Yes, sir. Can you hear me?
I can.
Well, good afternoon, Chairman Owens and committee members. My name is Randy Regier. I'm the Director of Reno County Community Corrections and the President of the Kansas Community Corrections Association. I was asked yesterday to stand in for Shelley Williams in support of this bill. I'll primarily rely on her testimony, but I'll keep my comments brief. People assigned to supervision have a list of conditions they're required to abide by to be successful. Violating these conditions can result in revocation, sanctions, or other interventions to address the behavior. These conditions are different between agencies and greatly vary across the state. This bill strives to meet three primary goals. First, the bill will provide standard conditions for all court services, state parole, and community corrections supervised offenders. Courts will still maintain the ability to add special conditions of supervision, which are specific to the risk and needs of individual offenders, but the standard conditions will be the same for everyone. Second, the bill aligns supervision conditions with best practices within our field. Our goal was to draft conditions that are realistic, relevant, and research supported. Third, this bill reduces the number of standard conditions. These conditions are targeted at reducing the behavior associated with risk. They're focused on behavior change, and they're supportive, and they support positive outcomes. I am recommending the passage of House Bill 2658. Thank you, Chairman and committee members, for your time, and I'm happy to stand for any questions you might have.
Thank you, Randy. Do we have questions for Randy, committee? All right, hold on, Representative Carmichael.
Thank you. I'll try to change the background again, Mr. Chairman. Mr. Regier, thank you for being here. Could you just explain to us, because I used to have misunderstanding and I may still have it, about the difference between community corrections and Department of Corrections work release programs?
Okay, so I think that it's always important to start out with the three different entities. You have court services, which is under the Office of Judicial Administration, that are state employees. We have state parole, which are people primarily released from facilities. And so, like you said, they may go to work release. And then we also have, and again, state parole is under the Department of Corrections. And then community corrections is a little bit separate. We are actually county employees. We're state funded through grants from the Kansas Department of Corrections. So we're a little bit separate. Yeah, we are under counties. Both court services and community corrections, if our clients our clients are assigned by the courts, and if they violate supervision, they return to the courts. Their jurisdiction is with the courts. With state parole, they're under the authority of the paroling board. So if someone is released from a facility and goes to a work release facility, they're still going to be responsible to the paroling board, not to back to the courts. Does that kind of help answer that structural question?
It helps greatly. So if some of my constituents are upset about work release, they shouldn't be blaming that on community corrections. Would that be generally fair?
That's generally fair. Community corrections operates two residential facilities, one in Sedgwick County and one in Johnson County. A lot of the funding for those comes from their counties, and so that you do have some people working in a residential facility or living in a residential facility on community corrections, but those numbers are pretty limited.
But that residential facility in Sedgwick County is different than Department of Corrections Work Release Center downtown, I believe.
I believe that's correct, sir.
Thank you.
Any additional questions? Representative French.
Thank you, Mr. Chairman. I see a lot of changes from what the current statute has versus the new recommended items. Can you explain why we are taking out permit the court services officer or community corrections service officer to visit the defendant at home or elsewhere?
Yes, sir. We would actually not eliminate those things in practice. So we can visit those clients anywhere while they're on supervision. We really just wanted to clean up the wording for those things. One of the things you'll see in the change in wording is it's important to understand that there's a couple primary reasons an offender is revoked from supervision. Primarily, it's because of either one of two areas: a new felony or misdemeanor offense, or they have absconded from supervision and they have just refused to comply with conditions and won't attend treatment or won't make themselves available to their officer. We would continue to see those people either at their residence or in the field at their employment. We would not be removing that ability. We would just want to change the wording in those statutes.
Okay, and there's also the one about work faithfully at suitable employment insofar as possible. You're taking that one out also?
Yes, sir. It's interesting as we dig into that. Research does not support the fact that employment prevents someone from engaging in illegal activity. So we would still have as part of our supervision that clients should be employed, but it's not going to be an issue that's going to be of a primary importance. Many of the people that we supervise, they are addicted to substances. They're dealing with significant mental illness. And so until we address those core issues with a person, employment's very much a secondary issue. So for a very pro-social person, we tie a lot of weight to employment. But for our clientele, usually that's kind of a secondary issue. And so we want to make sure we're following research and we want to address those core issues first. So we will certainly still want our clients to be employed, because they're not going to be able to pay their restitution and court costs if they're not, but that's not going to be the primary focus.
Okay, and you also took out the one support the defendant's dependents?
Yes, sir. That's actually not something that a client could be revoked for. I've never seen or heard of a situation where the courts would revoke someone's supervision for failing to abide by that condition. So I think that part of the thing that we wanted to do was make sure we're dialing in on what's important to the court. So it's not that the court's not concerned about people supporting their dependents. The issue is whether this is a reason that we would revoke someone, have them serve their underlying sentence or not.
Okay, and I think that's the only three that I really highlighted. The first two you said they're still being considered. I don't understand why you took them out if they're not being considered.
Well, we took those out because they would not be in the core list that we would want all the agencies to abide by. So in practice, we would still be able to do those field visits and those home visits, but it would not just, it doesn't need to be included as a condition of supervision.
Okay, thank you, Mr. Chair.
Thank you. And yeah, and I might add to this that the goal here is for standardization, for all of the probation-related agencies to be able to utilize these same terms so that there's no confusion or conflict amongst agencies wording things differently. But as you'll see in the last paragraph of the bill brief, it also allows for those additional imposition of special conditions based on the individual circumstances of that person. Additional questions? Representative Osmond.
Thank you, Mr. Chairman. Actually, you touched upon the point that I wanted to bring up, which was, as I understand it, this bill is designed to standardize probation requirements. So I just want to try to understand, because I might be missing in here. It looks as if you're taking out, or the recommendation is to take out a number of probation requirements and insert other probation requirements. How does that standardize the probation requirements across Kansas?
Sure. So what we did was we started by reviewing all the conditions that people use across the state. We wanted to make sure that we hit the primary conditions that were important to all jurisdictions. And as we refined that list and we came up with a list of standard conditions that we would recommend statewide, we then went back and compared that to statute to see what would need to change. And we found that there are these items that have been crossed off of the prior statute. Those are things where we're wanting to change that. So some of those wordings are still going to be we're still making a similar point, and we're still going to do similar work, but we're just wanting to do a very standardized list of conditions.
Thank you. I'm just still trying to understand, though, is there a mandate in here that they adopt, that every individual court jurisdiction adopt these particular standards? What is to stop them from doing the same thing that they're doing under the current law, which is imposing various requirements in various jurisdictions?
Yeah, we wanted to have a very standardized list of conditions for all agencies, and this would be the basic list that everyone on supervision would have to abide by. But we do want to make sure that we aren't limiting the court's jurisdiction if certain additional conditions need to be imposed. For example, with a sex offender, a court would want to impose contact restrictions. Maybe in the case of a theft or a burglary, the courts would also want to address contact with victims. And so we want to make sure we allow the courts that ability still, but we want to have a core list that's effective for everyone on supervision.
Okay, thank you.
Representative Heiberger.
Thank you, Mr. Chair. Is it fair to say that as probation conditions proliferate, the number of probation revocations increases?
I think it's going to depend on jurisdictions. As I stated previously, the primary reasons that people are revoked are very core issues: new offenses and refusing to attend any probation event, or we cannot locate the offender. I think that part of the issue is some of the conditions are, some conditions, if violated, will result in revocation. Some conditions are just wise recommendations for a living. So for example, we might have a condition that would say something along the lines of that they need to get permission before spending more than $250. Well, that's just wise living in that they need to think through how they're spending their money, but it's not a reason we would actually revoke someone to prison. We want to focus more on some of those core issues, and we do want to work with our clients on their financial stability to make sure that they're paying their obligations to the court and to, again, support defendants, dependents. So again, some of those things are just wise living type of things. Again, if you consider a curfew, you know, most likely if you're not out past midnight, there's a better chance you're not involved in trouble. So some of those things were just wise living, but it may not result in revocation of prison.
I guess my question wasn't intended as a criticism of this effort. My understanding is one of the purposes of this effort was to reduce the number of unnecessary probation revocations.
Yes, sir. I think it would reduce the number of minor violation or technical violations.
Thank you. Representative Smith.
Thank you, Mr. Chair. I'm looking at page 4, line 36 of the bill that states any law enforcement officer conducting a search pursuant to subsection struck the old section of C5, inserted the new section of B12, shall submit a written report to the appropriate court services officer or community correctional officers. The written report shall include later on, shall include certain things. I see that what it is striking actually replaces almost the exact same language. But if we go back up to B12, that subsection is to submit to searches of the defendant's person, effects, vehicle, residence, and property by the defendant's supervision officer or law enforcement officer based on reasonable suspicion that the defendant violated conditions of supervision or engaged in a criminal activity. One of the problems that I've had with that in the past is there's a requirement within statute then that says, as a law enforcement officer conducting that search, that I shall provide that report. It doesn't say that you requested it. It says I shall, which assumes that I know that that individual is under supervision. And if I don't know that that individual is under supervision, I don't know to provide that report. Would you have a problem if I changed the wording of that from a shall report to shall provide a report at the request?
Yes, sir. So the way that this has typically worked in the past under statute is that the law enforcement officer either needs to get approval from the supervision officer based on that their reasonable suspicion, or they can do that without the prior permission as long as they submit the report. So I think that the issue at hand is that it's important for the officer to know, the probation officer to know that was done.
Yeah, yes, I understand that, but I'm proposing a scenario that occurs where, as the law enforcement officer, I don't know that he or she is under supervision, and I conduct a search based on criminal activity that I have reasonable suspicion they're conducting. In other words, so separate from that, but it's included within the statute. Outside of their supervision, I'm acting as a law enforcement officer based on how I would react to anyone else. And so therefore, I don't know that. And with that shall in there, it kind of sets us up to fail.
Sure. I do not believe that in any way that this statute is designed to limit a law enforcement officer's ability to conduct a criminal investigation or to search. So I would not be opposed to that change in language.
All right, thank you. Additional questions, committee? All right, not seeing any, we'll go ahead and thank Randy for his time, and we'll move to hear from Patrick Armstrong on behalf of Jennifer Kaisea of the Council of State Governments.
Thank you, Chairman Owens, and thank you, committee, for allowing me to testify today. And I just want to thank you, committee, for the good questions as well, and glad that we had Randy on hand, since he's an expert in the system, has been living and working in it so long, and was able to answer some of those nuances. I wanted to provide a little bit of context that Natalie alluded to at the beginning, that this recommendation is coming from the Reform Commission work, and wanted to remind folks that the conditions they came to after thorough deliberation and a review of all the conditions across the state and how they're currently used, and not just in this regard, but in all the other regards that the supervision committees were looking at various issues. And our organization was able to help in that effort by gathering those conditions, first of all, but then also speaking to officers in each and every county in the state. And that's the type of support that we were able to provide, because folks like Randy, who gave us his testimony, and Shelley, who was chairing the committee, they obviously have to do their jobs and make sure that community supervision is happening in addition to doing this work on the committee. So our work was to try to bring in the feedback and ideas and minds of other community supervision officers to make sure that they were also included. So while there was only representation of court services and community corrections and KDOC supervision on the working groups, just wanted to let the committee know that we wanted to make sure that the input was brought in from all across every county and every jurisdiction in Kansas. So wanted to cite that for you all on this bill, but then also on the bill that we have coming up that's also supervision related. And I can stand for questions on process and how we did the work, or the bill itself if you all have any. Thank you.
Thank you. Any questions for Patrick Armstrong? All right. Not seeing any. Thank you, Patrick. Is there anybody else here that wishes to speak on House Bill 2658? All right. Not seeing any. We'll close the hearing on House Bill 2658 and move into House Bill 2654, which is, again, a product of the Criminal Justice Reform Commission, and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2654 would provide guidance to determine how offenders who are under the supervision of 2 or more supervision agencies can have that supervision consolidated under one agency. The bill amends KSA 216610. That's the statute that provides for the transfer of supervision of offenders on probation, community corrections, or under a suspended sentence. This section is amended to provide that when a defendant is being supervised, the district court by which the defendant is currently being supervised can use the guidelines in this section to determine whether it's appropriate to transfer jurisdiction to a different court. If a new sentence would place the defendant under the supervision of 2 supervision entities, the court may consider granting jurisdiction to the court with jurisdiction over the offense with the longest sentence. And they can also consider whether the severity of the new offense requires a higher level of supervision. If not, then preference would be given for maintaining supervision by that current supervision entity. But if so, then the preference would be given to transferring supervision to an appropriate supervision agency who can handle that higher level of supervision. If 2 or more supervision entities are supervising the defendant for sentences that are equal, then the court can consider the residency of the defendant, the ability of the defendant to travel to the supervision office, the resources for residential and non-residential treatment available from each of those entities, and the level of supervision that's available to the defendant by each of those supervision entities. The Department of Corrections and the Office of Judicial Administration would be required to enter into a memorandum of understanding, providing that a defendant shall be supervised by one supervision entity, and the bill then provides everything that should be included in that memorandum of understanding. And I can take any questions.
Any questions? Representative Wheeler. Could we get you to speak into the microphone, Representative? That's all right.
Thank you, Mr. Chairman. I apologize for my omission. Could transfer from one supervising agency to another, but the receiving had to consent to the supervision. Is that still the case in this?
So if up in subsection A, I think is what you're talking about. And so that still does require the concurrence of the receiving jurisdiction. This will be in cases, so that case is kind of like you live in Wichita and you're moving to Lawrence. And so your supervision, can be transferred as long as Lawrence agrees to take you. This supervision is you've committed one offense, and so you're on probation, court services probation, and you've committed another offense that puts you on community corrections supervision. This is how they can consolidate that supervision into one entity, so you don't have a court services officer and a community corrections officer supervising that same defendant.
Clarifies a great deal. Thank you very much.
Thank you. Additional questions? All right, seeing none, thank you, Natalie. We will again turn our attention to Randy Regier, who will be giving his testimony and on behalf of Shelley Williams. Randy, take it away.
Thank you again. Thank you again, Chairman and committee members. As stated, I'll be stepping in again for Shelley, and I'll keep my testimony brief. The issue of dual supervision was identified by the Criminal Justice Reform Commission as an inefficiency which unnecessarily complicates our system. Dual supervision occurs when an offender is being supervised by multiple supervision entities on separate cases, as previously stated. This can either be within the same jurisdiction or different jurisdictions across the state, and this is not uncommon for offenders who have advanced deeper into the criminal justice system. Agencies across the state have worked to minimize the problem of offenders being supervised by multiple agencies, and this bill builds on these efforts. Currently, agencies transfer clients between jurisdictions or share supervision responsibilities when an offender is being supervised by multiple agencies within one jurisdiction. This bill provides a more structured framework to ensure efficiencies for supervision agencies and reduce unnecessary challenges and confusion for offenders. This framework will provide a more formal directive for who will provide supervision, enforcement of court orders, and promotes improved communication between agencies. I am, again, recommending passage of House Bill 2654. Thank you, committee members. I'll be available for any questions.
Thank you. Committee questions? All right, seeing none, we'll move to Patrick Armstrong on behalf of Jennifer with the Council of State Governments. Patrick.
Thank you again, Mr. Chairman, and thank you, committee. I wanted to mention a couple of things that I didn't mention a moment ago, and that's a reminder of why these bills are important. And I won't review the testimony that Randy mentioned or that we submitted verbatim, word for word, but I will remind folks of something that's important, I think, that Representative Heiberger alluded to earlier, and that's part of what the commission's task was not to look at these discrete things, but instead was to look at supervision as a whole and find ways to make sure that people can have more opportunities to be successful and live stable, productive lives. And in order to do that, the effort of the commission was to eliminate certain barriers and things that would put them in a position that might lead to failure. And those conditions, as Representative Heiberger asked about earlier, when there is a bunch of them and they're confusing and they're different depending on what place that you're in, or they have things in them that don't necessarily have anything to do with about being a law-abiding citizen, those small mistakes or condition violations could add up and lead to someone getting in trouble and then being revoked, which is expensive for the state. Similarly, on dual supervision for this bill, if someone's supervised by more than one agency, that means they have to report to 2 different agencies. They might be paying 2 different supervision fees. And again, it makes it a challenge for them just to live consistent, productive lives if they have to go to work, but they have 2 meetings to report to, for example. So this bill is, while it's about a discrete topic, it's about the concept and the idea of making it easy for people to, making it easier for people who are trying to be compliant and not get tripped up by small things that don't really have anything to do with being law-abiding. And if one agency is supervising, they can do a very good job of monitoring those folks and communicating information, as opposed to having 2 separate people doing the exact same job and wasting state resources. So this bill attempts to reconcile that. I'll also say what the bill doesn't do, because I believe there may be some confusion. I read some opposition testimony earlier today, and it was from the court services officers, but I wanted to let the committee know that, again, court services officers statewide were involved in this process and helped to craft the bill. And we talked to court services officers in every jurisdiction, in every county, and we actually agree with the concepts that were in the opposition, and those concepts were that supervision should not be inefficient and it shouldn't be bogged down. It's that the supervision officers know very much the people that they're working with, and they also know the resources in their communities better than anybody. The supervision officers should not have to go to the court every time they want to transfer supervision or if every time a person moves. And the supervision officers should not have to go to the court if they want to adjust supervision levels based on risk assessments. And for some reason, there was some confusion about thinking that this bill does those things, and it does not. So I wanted to clarify that the bill is about efficiency and about productivity, and to the extent there's any confusion amongst officers that we've spoken to in the past or we haven't spoken to, wanted to let the committee know that we're working in collaboration with Chief Court Services Officers and the Office of Judicial Administration to make sure anything that this committee passes or that goes into law is done with their partnership and with their understanding of that the bill is going to be productive for them, as is our understanding at this moment, given all the folks that we got a chance to engage with. So I wanted to clarify those pieces of information in the event that they might have confused other folks. But this is beneficial to the supervision entities, all of them. And if it wasn't, we wouldn't be endorsing it. So I want to say that our organization, the Council of State Government, supports this bill as well, and happy to stand for any questions.
Thank you, Patrick. Committee, any questions for Patrick? All right, I am not seeing any. Is there anybody else that would like to speak in regards to House Bill 2654? All right, seeing none, we'll go ahead and close the hearing. I do want to mention that there is written only proponent testimony from Stephanie Springer, the Kansas Association of Court Services office. So with that, we'll close that hearing and we will move back into working on House Bill 2674 that we were discussing yesterday, but decided to table until today, pending an amendment. And we'll ask Natalie to give us just a brief overview on that.
Thank you, Mr. Chairman. House Bill 2674 would require a forfeiture of an appearance bond to be set aside in certain circumstances.
Very good. And Representative Wheeler, did you end up working with the reviser to have an amendment drafted?
I did, but I'd like
No problem. If you have that, we'll go ahead and get that distributed. While that's being distributed, feel free to share with, well, hold on.
Mr. Chairman,
Yes, sir.
while we are waiting, I had also asked for an amendment, which frankly, I think was a little better than Representative Wheeler's, but it's only a matter of style, not substance. And so rather than delaying the committee's proceedings, let's forego mine, and I appreciate the efforts of those involved. And we'll just run with John Wheeler's amendment. And if it blows up in the future, he can explain it to somebody instead of it being my work product. Thank you.
Mr. Chairman, mine was punctuated properly.
Very good.
And if
And
anything
yours was
else, I have
punctual
one
as where, and I was pontificating on the floor instead of working on the business of this committee. I'm sorry.
Feel free to work on the business of the committee next time. All right. Has that been distributed at this point, Natalie, or are we still in that process? People are feverishly typing on their keyboards as the amendment is on its way. Very good. All right, Representative Wheeler, would you care to share with us the substance of your amendment? I guess our pages had enough of the committee and just said we're out. I don't know.
Mr. Chairman, I operate my computer with a mouse. And this little thing down here is completely foreign to me. In fact, it is kind of like it's Lithuanian.
All right, well. as long as-
Essentially, what my amendment does is. Yeah, thank you.
Hey, it takes a team. Takes a team.
It is addressing the portion of the bill that directs that a court can set aside a judgment on forfeiture in certain events. And there's an amendment to subsection C, when the surety has submitted a written request to the court in the county where the forfeiture occurred to enter the warrant for the defendant into the National Crime Information Center Index, commonly known as NCIC. And such warrant was not entered within 14 days. And then we add, well, the court is to order the sheriff to enter it into NCIC, and within 14 days, and if the sheriff fails to do so, it can be shown that there was good cause that they were unable to do it. And I give an example where the warrant officer may have had COVID in his home. And essentially, I have bungled that up badly enough. I'm going to leave it to you. And
I think everybody has a copy of this in their inbox and has had a chance to review it. Committee, are there questions on this amendment?
essentially what this does is that the request is filed with the court, because then it becomes a part of the official court record. The court will then order the sheriff to do it. And that's the essence of it.
Makes sense. Would you care to move your amendment?
I move my amendment.
Very good. Do I have a second, committee? Representative Resman. Representative Smith, you have a question.
So essentially what you're saying is the forfeiture can be set aside if the court directed it, but it didn't happen. The sheriff didn't get it taken care of.
On good cause.
Right, right.
And the reason why I put on good cause is because you will call testimony of certain jurisdictions who didn't enter into NCIC and yet went ahead and granted default judgment on the bond when they really had made no effort to assist the bond person to find.
I see no issue with that.
And it also, what I like about it is it also puts it as part of the court record. So there's no, I stopped by the sheriff's office on this date at this time, and they didn't do it in 14 days. So I agree. Are there any other questions on this amendment? All right, seeing none, you may close, Representative Wheeler.
I close, Mr. Chairman, and move my amendment.
Very good. Thank you, sir. All in favor of the Wheeler amendment say aye. Any opposed, no? Very good. We're back on the bill. That passes. Are there any additional amendments or any other conversation as it relates to House Bill 2674? Seeing none, do I see a motion as it relates to House Bill 2674? As amended. Very good. Do I have a second? Thank you. Representative Smith seconds. Committee, any other discussion?
Can we make sure the arriving member knows what's on the table?
Representative Carmichael's walking in behind you. And, you know, it's like he mysteriously appeared out of our television. I don't know what else is there. Are you aware of the motion?
Mr. Chairman, I am aware of the motion. And to speak the motion, it's a fine, fine piece of legislation.
Very good. Members, all in favor of passing House Bill 2674 favorably, say aye. Aye. Any opposed, no? The ayes have it. Anybody wish to be recorded? Representative Carmichael, Representative Heiberger. Thank you. Moving right along to House Bill 2657. Natalie would give us an overview.
Thank you, Mr. Chairman. House Bill 2657 would enact the Reduce Armed Violence Act, and it would increase the criminal penalties for certain violations of criminal possession of a weapon convicted by a convicted felon that involve firearms. And I can take any questions.
Very good. Any questions? Committee, did anybody have any amendments on this bill? Representative Heiberger.
Mr. Chair, I do have an amendment.
Very good.
It's almost as simple as the two bills I introduced in judiciary.
We will get that distributed. In the meantime, would you care to discuss it?
Yes, it's a very simple bill. What it does, it strikes out in subsection something U on page 11 from the list of offenses that occurred, it strikes out 215706, which is simple drug possession.
Very good. So it strikes out here is that balloon. Looked like it just hit my email box here.
I would note for the committee that if you look up on page 10, which is not in the balloon, this is a list of crimes that are defined as violent offenses for the purpose of the enhancement we adopted, or we are discussing. And I guess I don't believe that simple drug possession is a violent offense, and I think it would, just removing this, as testimony of the defense attorneys yesterday indicated, would help ameliorate some of the impact of this on nonviolent offenders.
Okay, maybe I'm not quite following. And so give me a little bit of clarification here, because this appears that we are amending the sentencing guidelines for non-drug grid crimes. I'm sorry, maybe okay, if you want to share with us, Natalie, because I'm a little bit confused here.
Thank you, Mr. Chairman. The underlying bill actually amends the sentencing grid, because what the underlying bill does is add a special sentencing rule that says if you are a convicted felon in possession of a firearm and you're committing one of these dangerous felonies, then you are going to have presumptive imprisonment, and those sentences are going to run consecutively. So what Representative Heiberger's amendment does is take possession of controlled substances out of that list of dangerous felonies.
Okay, just again, for my formality and from my understanding, is there a reason that we don't have a balloon on the bill that just strikes 21, whatever, 5706?
That is what the balloon does on page 11, or
Gotcha.
Yeah.
Okay, now I'm seeing it. I'm looking at the top of this, and
Oh, sorry.
I didn't
Yeah, the
scroll
first
down
page.
to the second page to make it compute in my brain. Thank you. Representative Smith.
Okay, so getting into 215706, this is commonly the statute that we would use in law enforcement anytime we're going to charge somebody with any quantity of certain controlled substances. And then it sets out within those individual lines, line 1, line 2, depending on where you go to. It gets confusing. In fact, new officers have a hard time with this because it does cover such a broad spectrum of controlled substances that you need to be specific about which line you're going to charge them with. It could be as simple as marijuana, a small quantity of marijuana in your pocket, but it also, 5706 covers methamphetamine, heroin, cocaine, quantities of such, dangerous quantities, and the use of firearms in the distribution of these substances is common, and also in protecting themselves to go and obtain these substances is common. And I think that is what the nature of why it was included to begin with, or at least that's what I took out of it. I think to strike the entirety of 215706 is not, I think it ignores what the rest of the statute may mean, even though we do have minor quantities included in 215706. I'll give you that.
Additional discussion, committee. Better check online. See nobody else online. Representative Heiberger, do you care to move your amendment?
Yeah, I'll just say that, again, these, even though they do involve some drugs that are more serious than marijuana, and people may be involved, using weapons in drug distribution, these are possession crimes. They are not violent offenses as stated in the statute. And I think I think it would be beneficial to not automatically send folks in this position to prison.
You care to move your amendment?
And I move my amendment.
Very good. Do I have a second? Second by Representative Osman. Any additional question, committee? Representative Carmichael.
Thank you, Mr. Chair. I'm stepping out on a limb here, and I'll promptly cut it off behind myself in a minute. But you know, if you respect the Second Amendment, the right to keep and bear arms, I hate to tell you this, but there are some folks who exercise their Second Amendment rights who also have some marijuana laying on the coffee table, and that's very different than somebody who goes out and uses a gun in the commission of drug crimes or other violent crimes. I support the amendment. Thank you.
Thank you. Representative Howerton.
Thank you, Mr. Chair. Because of the way the statute is written, is there a way to separate that? The types of drugs?
That's a great question. Natalie?
Mr. Chairman, if the will of the committee would be to only include possession of certain types of drugs, those could be listed out. That would be possible, yes.
Okay, good to know. Additional questions? Representative Smith.
I think also, if one were concerned only about that, then they could make that exception within there as well, 215706, subsection such and such, with that exception in there. Wouldn't that also be a possibility?
I don't think I quite understand that question.
Well, if you're concerned only about, Natalie, if you're only concerned about the marijuana and those who might have marijuana, then making an exception for the marijuana in small quantities.
Mr. Chairman, yes, you could do that. I'm not so sure about the small quantities because you would have to have the trier of fact make that determination, I suspect, or else you would have possibly an Apprendi issue. I'm looking at Jessica hoping that she'll jump up and down if I say something wrong. But because a conviction under that statute's not going to require them to find what the quantity was, then you can't then use that quantity to enhance them later. But if you wanted to exclude a drug, a type of drug in its entirety that could be identified on the controlled substances schedule, then yes, we would be able to do that.
Representative Carmichael.
Thank you, Mr. Chair. We're getting closer to something that seems where we ought to be. I'm certainly not talking about the guy or gal who's got 5 pounds of marijuana because they're possessing it with the intention to distribute. But, you know, if you're right. But still, somebody's got a large quantity of it, whether you can prove they're intending to distribute it, they're planning to parcel it up. But I'll be honest with you, I know a lot of veterans who possess firearms and also possess small quantities of marijuana. I know a lot of people I went to high school with I could say the same thing about, and I won't speak to myself. Thank you.
Thank you. Representative Osman.
You have a gun?
Thank you, Mr. Chair. I also support this amendment. I mean, we look at the language of the proposed bill itself, and it talks about using this subsection, violent felony. Then it lists them off. Things like capital murder, murder in the first degree, murder in the second degree, running down aggravated robbery, running down rape, aggravated arson. Like, there is no question in my mind any of these can be described as violent felony. Then we get to the one that is, one of these things is not like the other, possession of a controlled substance. Now, what you do with it may be violent, that is a separate offense, but the possession itself isn't violent, and it doesn't seem in place with any of these other amendments or any of these other types of felonies that are listed in here. So yes, I would support the amendment to strike that from this bill.
All right, thank you. Committee, additional questions or conversation? Representative Keither.
Do I have my hand up?
No, I thought I heard you mention that you had a question, and maybe I wasn't missing you, so.
No, I'm sorry, no. Mm-mm.
Very good. All right, thank you. Any additional questions or Representative French?
Thank you, Mr. Chair. Talking about levels of criminal activity, can the revisor tell me the difference between, say, burglary and aggravated burglary? And aggravated kidnap and regular kidnapping?
Yep, stand by just 1 second. She's pulling that up for you.
All right, so for kidnapping, just typical kidnapping is the taking or confining of any person accomplished by force, threat, or deception with the intent to hold that person for ransom or as a shield or hostage, to facilitate flight or the commission of any crime, to inflict bodily injury or terrorize the victim, or to interfere with the performance of any governmental or political functions. Aggravating kidnapping is performing that same act of kidnapping when bodily harm is inflicted on the person being kidnapped. And I'm sorry, what was the second crime that you wanted?
Burglary, particularly, I was interested in. So basically, aggravated means bodily harm was.
Not all the time. So in the specific instance of kidnapping, that's the case.
Okay.
But let me get you the. Okay, so burglary is without authority entering into or remaining within any dwelling with the intent to commit a felony, theft, or sexually motivated crime, entering into a building, manufactured home, mobile home, tent, or other structure with the intent to commit a felony, theft, or sexually violent crime, vehicle, aircraft, watercraft, railroad, or other means of conveyance, same with the intent to commit a felony, theft, or sexually violent crime. And then aggravated burglary is entering into or remaining within a dwelling in which there's a human being with the intent to commit a felony, theft, or sexually motivated crime. So if a person were home in that dwelling, then that would bump it to aggravated. Same with the building, same with the vehicle. So the difference in that one is that there's a person that's in the establishment that is being burgled.
Okay. Thank you, Mr. Chair.
Certainly. Additional questions or conversation, committee? All right, seeing none, if you would like to close, Representative Heiberger.
Sure. I just give one more example sort of related to what Representative Carmichael was alluding to. So it involves my cousin Bob. You know, he was kind of wild in his younger days. He got a felony drug conviction as a young man. 10 years later, he's out hunting, got his hunting rifle, got a bag of pot in his pocket, driving home. He's got a taillight out, gets stopped by the police. Bam, he's looking at presumptive prison. And I guess I don't think that was what the intent of the bringer of the bill had in mind. So.
All right. You have heard the amendment, heard the discussion, committee. All in favor of the Heiberger. Oh, do you have something? All right. All in favor of the Heiberger amendment, say aye.
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 All opposed, say no. Noes appear to have it. Noes do have it. Amendment fails.
Division, please.
Yep. You may do so. Requested has been for division. All in favor of the Heiberger amendment, please raise their right hand. 1, 2, 3, 4. I see 4 hands raised. All opposed, All no votes, raise their right hand. 1, 2, 3, 4, 5, 6, 7. Looks like 7-4.
My hearing was poor, your chairmanship. I wouldn't have requested that otherwise.
It's all right. Thank you. Thank you. All right. So the amendment does fail. We are back on the bill. Only out of respect for your friends with marijuana.
And I
on
do
their
not
table.
approve of people hunting while they possess marijuana, but the coffee table's okay.
Representative Carmichael and Heiberger are recorded
It's
as
just like
either.
talking to Bob sometimes.
All right, committee, we are back on the bill. Are there any additional amendments on House Bill 2657? Any additional discussion at this point? Oh, yes, Natalie, thank you. Hey, I have an amendment on this one. Hold on 1 second for me. See, this is why we need Natalie, and you know if your nieces were still here, they would, I know, they left you hanging. Okay, yeah, that's right, pull up the live stream. Okay, if we'll go ahead and distribute 2657, and this is very much a technical amendment that I will be certain to allow Natalie to explain for me.
Thank you, Mr. Chairman. And this was actually brought up in testimony yesterday. If you look on page 11, starting at line 23, it says any felony offense is provided in KSA 2021 SUP 216308A or B. I don't know why this one was drafted differently. You heard the Attorney General speak yesterday that this list was taken from some other list, so I suspect that could be why. But to include both of those subsections could inadvertently include a misdemeanor. So we're basically cleaning it up to just name the crime, which is criminal discharge of a firearm. And then we're only including subsection A1 and subsection A2 because those are the felony versions of those offenses.
Thank you, Natalie. And I will move that amendment. Do I have a second? Representative Smith, thank you. Additional questions, clarifications on this amendment? Certainly. We'll give just 1 second for that to hit your email box. And it's the very end of that PDF document. Thanks. Appreciate that. All right, we have a motion and a second. Are there any additional questions or conversation?
I have a question. So those two sections are discharging at a dwelling or other that is occupied. Is that correct?
Mr. Chairman, I should have anticipated that question. Let me bring it up really quick. So A1 is the reckless and unauthorized discharge of a firearm at a dwelling, building, or structure in which there's a human when they have reason to know or they do know that there's a human present, or at a motor vehicle, aircraft, similar, when there's a human being there and they know that or they have reason to know that. And then it would also include the reckless an unauthorized discharge of a firearm at a dwelling when there's no human being present. So those two are the types of felony versions of this offense.
Representative Carmichael.
Thank you, Mr. Chair. Okay, I'm the bad guy. I got the gun. And I know that somebody's inside this building. It's not a dwelling. I shoot at it. That's aggravated under the statute, if I understand it.
Sorry, Mr. Chairman, let me repeat it back to make sure. So you're a bad guy with a gun. You are at a dwelling. You know there's...
No, I'm in a building. I'm sorry, a building, but it's occupied. It's not a dwelling. It's an occupied building. I know it. I shoot at it. That's aggravated, I believe.
Well, it's not aggravated, but it is a felony version of
Felony
criminal
version.
discharge of a firearm. Yes.
Okay. And same thing would apply to a vehicle or an airplane or a truck. If I know it's occupied, I shoot at it, that's a felony.
Yes.
If it's a dwelling place, it doesn't matter whether somebody's there, not there, or whether I know they are there or not. Shooting at a house is a felony.
Yes, as long as it's reckless and unauthorized. Yep.
Ooh, that means I could shoot up my own house when my wife is home. I don't know that's a good idea. We might ought to work on that. Thank you.
Thank you. Any additional questions or clarifications? Just make sure your marijuana is off the table, or your friend's marijuana is off the table.
If you'd ever seen my wife's gun collection, you wouldn't worry about her safety.
There you go. All right, committee. With that, I will go ahead and close and move my motion. Everyone in favor of the amendment on House Bill 2657, say aye. Aye. Any opposed, say no. All right, that amendment is there. Moving forward, back on the bill, House Bill 2657. Do I have any other amendments? Okay, good. I'm glad. Very good. Do I have a motion as it relates to House Bill 2657? Go right ahead.
Thank you, Mr. Chair. I move that HB 2657 be passed out of committee as amended.
Thank you. Do I have a second? Representative Howerton's our second. Additional conversation, question, discussion, committee. Representative Heiberger.
Thank you, Mr. Chair. I would much have preferred if the amendment I had offered was passed. And I really don't like voting on bills that increase our prison population. But despite that, I think if there are people that should be in our prisons, it's people who are violating most of these sections. So I'm going to reluctantly support the bill.
All right, thank you. Additional comments, committee? Seeing none, you may close.
I close and move my amendment, or I move the bill.
We got it. All right, committee, all in favor of passing out House Bill 2657 favorably say aye. Aye. Any opposed say no. All right, the ayes have it. Representative Heiberger, Representative Carmichael would like to be recorded. Committee, that concludes our work for the day. As we were sitting here looking, it appears that we now have a winter storm warning issued for tomorrow. That alert has popped up, so we'll see what tomorrow brings. There's no telling, but just stay close to your emails. With that, we'll be adjourned for the day. Thank you.